Do you have children? If yes, here are 5 reasons you need to make a will. If you have kids, you need a will, plain and simple, and here is why. If God forbid you were to die without a will, a court, through a process called probate, will use state law to make many decisions on your behalf. From who will take care of your kids to what happens to your property, a probate judge will decide things based on state law. Nothing wrong with that. But if that's not how you see things, or don't want the government to meddle in your affairs when you're no longer alive, set up today a will so you can protect your children and the property. Welcome back, folks, to another edition of Sweetie Kiwi. How are you doing today? I hope you are doing fantastic. I'm doing splendid. If you are doing as great as I am, go grab a cup of coffee or tea or vodka and let's roll. Today I want to talk to you about the implications of children and will. Number one, the number one reason you need to make a will if you have children. A will gives you a say about who will take care of your children. If, God forbid, you die and your children do not have another capable parent to take care of them, a court will appoint a personal guardian to raise them. And courts have several criteria that they look at when appointing a personal guardian. In figuring out who to name for the job, the court will focus on the best interest of the children, and the court will generally ask for opinions of people who know the kids. Because you are dead in this scenario, you will not be able to weigh in, but you can use your will to be clear who you think should be named, and who you can even provide your reasoning in the will, of course. Now, your opinion will be especially important if there are different opinions within your family about who your kids' guardians should be. Times will be difficult enough with you gone. A family feud will only make things worse for your kids. Think about that. So your documented, written preference will make it easier for the court to make a decision and for your family to accept it. So that's the number one reason. A will gives you a say, an opinion, an important opinion about who will take care of your children once you're gone. Reason number two, a will allows you to name a guardian for your children's finances. When we talk about children's finances, we're talking about an important element because the financial stability of the children will go hand in hand with their moral, with their psychological, with their physical ability. If the kids are doing fine, if everything is taken care of, they're eating right, their school, their tuition is taken care of, you are going to have children who will blossom. So a will allows you to name a guardian for your children's finances. If, God forbid, something were to happen to you and you were gone, you will also need someone to look after your children's finances. You can name the same person that you named to be the children's personal guardian, or you can choose someone different. It all depends. If, for instance, you know that someone is the person you named to be the guardian for the children is someone with strong nurturing abilities but lacks financial expertise, then you might name someone else who has strong financial acumen to take care of the children's finances. Now, it is very important to understand that unlike your choice for personal guardian, the court will usually just accept your choice for property guardian unless the person you name is unavailable or obviously incompetent. Your children's property guardian will look after any of their property that is not already managed in another way. In other words, the property guardian would not manage property that was left to your children in a trust or custodianship. What are we talking about in terms of property here? We're talking about cash, so in the form of savings accounts or checking accounts. We're talking about property, real estate, a house, or anything else that you leave for your children. We are also talking about cars, boats, depending upon your financial situation. If you own collectibles or valuable property, valuable commodities, valuable precious metals, this could also go into the property. And in some cases, you have a case-by-case decision. So the probate judge will have to take a serious look at your personal and financial affairs and decides what's best for your children's future, for your children's life. Reason number 3, you can use your will to set up a long-term management for your children's property. So separate from naming someone to take care of any unmanaged property, you can also use your will to set up property management for the property you leave to your children. You can use your will actually to name a trusted adult to manage the property until the children reach a certain age. And a lot of people always think it has to be 18. No, you might decide to raise it to 21 or lower it to 16. It's all about what you want. You are the parents after all, and you know your children better. So you make a decision that you believe is in their best interest. The court will only strike down your preference if it believes that your decision, the content in your will goes counter to the benefits or the prosperity of the children. You can use your will to name a trusted adult to manage the property until the children reach a certain age. I said that before. Now, if you don't set up property management that lasts into their young adulthood, your children will receive their inheritance from you when they legally become adults, age 18 in most states. Number 4, reason number 4. Remember, folks, I'm talking to you about 5 reasons you need to make a will if you have children. Reason number 4, you can use your will to decide who will wrap up your estate. The person who serves as executor will have a big job after you die. He or she will manage the court process for wrapping up your estates and will have, in addition, to make many decisions, big and small, affecting your children's inheritance. So if you have an opinion, if you have, especially what we've seen in our research is that parents who have strong opinion about who would be the best for this job, then they put it in the will. So you want to name the person in your will. If you don't, what will happen is that the court will appoint someone and it will have to make an educated guess about who is the best choice. Remember, courts don't know your family. Courts have a series of standards and rules, and they look at criteria and they try to make the best decisions possible. But sometimes those decisions may not be what's really good for your family or what you would have wanted were you still alive. So you want to make those, you want to decide who will wrap up your estate in your will. Even if you're not worried that the court will make a bad choice, you using your will to state your preferences will minimize family conflict over the issue, allowing the focus to remain on taking care of your kids. As I just said, the court, no matter how reasonable and how competent the judges and all the other court staff are, they don't know your family. They don't know what's going on. They don't know the ins and outs of family dynamics. And they might make a decision that might create or trigger family conflict, and you don't want that. I'll be right back right after this. Don't go anywhere. Welcome back, folks, to another edition of the Awesome Sweetie Kiwi Show. We're also having a conversation here about 5 reasons you need to make a will if you have children. I've already given you 4 reasons. I'm going to give you the last one. But if you love the content, before I get into that, if you love the content's clarity and quality so far, please consider subscribing to our channel and turn on the notification bell so you are informed in real time whenever we drop a new show. We cover a lot of important and relevant topics in real estate, in estate planning, in wealth management, among other topics. So we release shows every single day, rain or shine. So if you turn on the notification bell, you are informed whenever we release a new show. Also, like this content, share, and most importantly, comment, ask questions. Our team will read all questions, and if we have a question that is relevant to the topic at hand, we will certainly get back to you. A will lets you decide who should get what and who should get nothing. Let me repeat that. This is a very important element in estate planning and probate proceedings. A will lets you decide who should get what and who should get nothing. If you have a strong opinion about a family member whom you don't want to leave nothing to, you don't want to bequeath anything to, you need to specify that. If you want your children to split your property evenly, then you may not be too concerned about using a will to decide who gets what. But your state's one-size-fits-all approach to divvying up property to family members may not be what you want and many small choices will be left to your executor. It's almost always better to use the will to make your wishes clear. Here are a few things to keep in mind. If you're married, your spouse and your children will split up your property using a state-specific formula. So you want to double check with your state or an attorney in your state to see what the formula is. The children will split the children's portion evenly. Your executor will have to make judgment calls about how to divide property that cannot actually be divided. I'm talking about cars, animals, furniture, including decisions about which items should be sold. So really the calculus here is relatively simple. Let's say you have 100,000 left. I'm just simplifying things here. Let's say you have overall 100,000 net left in your estate, and you have a wife and 4 children. What will happen is that in most states, you have 50% that goes to your wife and 50% that is evenly distributed among your 4 children. So you have 50 grand that goes to your spouse, to your wife, and 50 grand that goes to your 4 children. So each child will receive 12,500, and 12,500 times 4, that's 50 grand. And that's how most states usually do this. So, but if you have cars, if you have animals, if you have furniture, if you have emotional property, emotional assets, such as a ring that grandma gave you in the 1800s or in the late 1900s, that kind of stuff, it's kind of hard. But the executor of the estate will have to make a decision. So if you have any items that you want to leave to specific children, or if you want one child to get more than another, you must make a will to make your plan known. Otherwise, your executor will be obligated to make an even split as judiciously as possible. Remember, your executor is not into the family dynamics. He or she doesn't care about your preference for one next of kin, one child to another. He or she will do the best distribution possible. Also, if you want to leave any of your children nothing, you must make that clear in your will. Otherwise, that child may be able to claim a portion of your estate. Keep in mind that a will alone may not provide enough planning to cover your needs and the needs of your family. For example, if you have a substantial estate, you may want to save your family time and money by avoiding probate. Or if you have a child with special needs, you may want to set up a special needs trust. You might also consider buying life insurance to cover any big ticket expenses. And generally, most people should make healthcare directives and powers of attorney. This will allow your loved ones to make informed decisions about your healthcare or finances if you cannot make these decisions yourself. We've already covered the durable financial power of attorney and durable healthcare power of attorney in other shows, so you might want to double check those videos. So a healthcare directive is the same as a durable medical power of attorney. It depends on the state, but the terms might be interchangeable, but they basically mean the same thing. All right, folks, this is it for today. Really appreciate today's conversation, your attention here. The topic was very simple. I just gave you 5 reasons you need to make a will if you have children. And here is a recap. A will gives you a say about who will care for your children. A will allows you to name a guardian for your children's finances. You can use your will to set up a long-term management process for your children's property. You can use your will to decide who will wrap up your estate. A will lets you decide who should get what and who should get nothing. I will see you next time. But until then, remember, stay splendid.